Muted.
Hi everybody, this is Teresa Beck. It's noon on the dot, so we're going to get started. We're really happy to be producing this webinar for you today. I'm here with Patrick Klingborg. He's an associate at Lincoln Gustafson and Circos. Let's see, I wanted to tell you a little bit about our firm before we get into the details of the webinar. The firm was founded in San Diego in 1987, and since that time we've grown and expanded to Nevada and Arizona. We have offices in Phoenix and in Las Vegas. We're a mid-sized firm, which we think means that you have better access to us than you would with a larger firm, but you don't have to pay the same cost as a larger firm. Same kind of service, same top-level lawyers, but without the cost of a big firm. We're also a sponsor of a workspace sharing company called Downtown Works, which is really cool, a new business here in San Diego that we're proud to be associated with. And put a little picture there of our San Diego office for those of you that haven't been here. Patrick's going to talk now for a minute about the impact of employment litigation, and we'll get into our top 10 list in a moment.
Thanks, Teresa. This is Patrick. So, as many of you may know, employment litigation is a big deal in California, and we'll get into it momentarily, but California is also known as being employee-friendly, but we wanted to try and quantify that a little bit. So, some of the numbers you'll see on this slide are that a lot of small businesses face employment issues. The numbers here are from a large insurer and a study they performed, and there's a link down at the bottom if you want to take a closer look at it. But among the things they found there is that the average cost to defend an employment lawsuit is $125,000, and it could easily be more than that. Sometimes for a big case, that could be your budget for most of trial alone. So it's possible you could have another $100,000 on top of that for a big case. So I think this helps make it a little real and quantify it. And of course, the cost to defend is just defending. If you lose the lawsuit, you could have to pay a verdict on top of that, which sometimes can be quite large, as you can see there. So I think the kind of takeaway here is an ounce of prevention is worth a pound of cure. It can be, something people don't want to deal with in terms of talking to a lawyer or just taking or speaking with their HR people to take steps to prevent employment litigation. But it really is worth it when you look at numbers like this.
Right, and these numbers pertain to national figures, not just California. So keep that in mind. I know we have a few people on the phone from states other than California, and that average cost to defend is a national figure. Patrick, you want to talk about the resources?
Sure. So yeah, we wanted to give you all some resources you could take home, and there's a lot of information out there with anything on the internet, but we strongly recommend sticking with other than your lawyer, government websites, because there's a lot in the employment law process that's designed for people to, at least begin going through without an attorney. As such, these government websites have a lot of resources on their websites. For example, I know and here's a few you see in front of you here. These are all different agencies. The first two are California State. The third is a federal agency. And some of these, like for example, the DFEH website has a great rundown about termination pay. How much pay is due to an employee when they quit based on how much notice they provided, and they give these very detailed examples with just a normal wage, a wage that's dependent on commission, an independent contractor, all these different types of situations. So before you go scouring, the deep, dark crevices of Reddit subthreads and all kinds of things, I would recommend, look at the official word from the government websites first. And they're not going to answer all of your questions, but that's always a good place to start, so you know that this information is verified because it's up on this government website. And then, once you have that baseline understanding, then you're in a better position to, determine whether or not you need a consultant attorney, et cetera. So, I definitely bookmark these sites, take a look at them, and you can find a lot of your questions may be answered by visiting websites for these agencies.
Okay, and we don't have it on the screen, but for Nevada, you would go to the Equal Rights Commission for discrimination type issues and to the Labor Commissioner of Nevada for wage and hour type questions. So we wanted to give you a couple examples of real cases that happened recently which involved smaller type employers to give you some context for why these issues are so important and why paying attention to the top 10 list that we're giving you will really help. So this case was actually in San Diego, which is where our firm started. 5 nail salon workers sued the nail salon owner. They had worked for the salon for over 4 years. 4 years in California is an important benchmark because wage and hour claims can go back 4 years. So if you fail to pay an employee the appropriate amount, they can go back 4 years to recover all of the mistakes. They performed manicures and pedicures. They said that the salon deducted $1 from every paycheck for workers' comp insurance, which is a big no-no. We don't deduct anything from employees' paychecks, and that's typically across the board in any state. The paycheck is considered pretty sacred, so this was a problem. They also claimed they were denied rest and meal periods, and they weren't paid for all hours worked or for overtime. The salon argued that overtime was not owed because the plaintiffs did not work overtime, which is a typical defense. The salon owner said they purchased the store from a prior owner who taught them how to do business, and they just continued doing things in the same way, which I'm sure you can imagine is not a very good defense. Each plaintiff signed a form that permitted the salon owner to deduct that money for work comp, but it doesn't matter because the paycheck is really considered sacred, like I said. So the plaintiff demanded, or plaintiffs I should say, because there were 5 of them, they demanded $50,000 before trial, and the defense offered $20,000. So we wanted to know what you all think about what this verdict ended up being, and what you can do is go to your sidebar that you should have for the webinar, and then under questions you can post, might be able to try chat, but let's go with questions. You can post what you think the verdict was, and we're interested in knowing what your thoughts are. So let me give you a little context too for that. When overtime is not paid, or any monies aren't paid, an employee is entitled up to 30 days of pay for a penalty. So you can imagine these salon workers are probably minimum wage type employees, and so for every time they weren't paid overtime, there could be that penalty for a max of 30 days of regular pay. Another penalty is because the wage statement is going to be incorrect when you don't pay an employee correctly, and that's a violation also. And that violation is $50 for the first paycheck, and then $100 for every paycheck after that. That's incorrect. So that gives you a little bit of context about what the verdict could be. So we have 60,000, 200,000, 100,000. Any other guessers? 250. Let's see. 400. Yes, it can add up really quickly. So we have a pretty wide range, and this is good information too, because when cases like this go to juries, you're dealing with people just like the group that's here today, and we have a low of 60 up to a high of 400, and that's the kind of conversation that a jury could be having about your business when they're in the jury room deliberating about what the outcome should be, and that's concerning. So here is the outcome. $95,788 after a 2-day trial, which isn't too bad considering there were 5 workers and some clear violations with deducting the work comp. That alone could have been a lot, but still, we consider $95,000 plus they'll probably get their attorney's fees because these are wage and hour violations, and so this is just kind of a base number, and likely the actual judgment will be for more. Because once the plaintiff wins, they go after their fees. Okay, one more before we get into the top 10 list. This is a case involving 2 female bartenders versus the owner of the bar. They complained that they had been sexually harassed by their supervisor, and when they complained, they were retaliated against. The supervisor allegedly touched them, hugged them, would rub up against them while they were working. He made inappropriate comments about their bodies, all of which is very unprofessional, and that will be something we talk about later. He asked them to go with him to water parks so he could see them in bathing suits, and when they complained, their hours were reduced. And that reduction in hours is the retaliation. Once someone complains, this is a time to think about whether you really want to take some kind of adverse employment action with respect to them. So the bartender basically argued it didn't happen. Now it's their word against the bartender owner and the bartender himself. And this is another one we wanted to get your opinion on. So what do you think this one is worth? Now, as far as how you measure, it's not like wage and hour. There aren't going to be specific numbers for penalties and things like that. So what a jury will be discussing is what is the pain and suffering, basically, for these women having to work through this. And go ahead and list it on your question bar when you're ready. What's the pain and suffering? And then they had the reduction in hours, so they would get lost income for that. And if they have trouble finding another job for the time period that they're looking, they would probably be compensated for that too. So for bartenders, probably a pretty good job market. Might not be too difficult to find another job if they leave, and it would be reasonable to leave. We call that constructive termination when you're being harassed by somebody. So any guessers out there? Let me check. Okay, I see 100,000. I'm thinking this is joint total case. You know, the 2 bartenders. 250,000. 75, 125, 200, 150. So we seem to be kind of in the 100, 200 area. And let me tell you what it was. $50,000 basically plus attorney's fees. And something to think about in terms of attorney's fees is for a case that went all the way to trial, the attorney's fees are likely going to be, I would say, over $100,000. Plaintiff attorneys in the employment area usually get, I would say, between $300 and $400 an hour, and they're able to collect that after judgment. And when there's been a discrimination type of a claim like this, typically the fees will be awarded and are part of the claim. So I would say this attorney is probably going to get around $150,000, and it doesn't matter that he only collected $49,000. I'm hearing a little background noise, so I'm going to go in while Patrick's going to start our top 10 list and try to fix that. Patrick, go ahead.
Okay, so let's kick off the list. Number 10 thing you need to know is, generally speaking, California law will be on the side of the employee. And what we mean by that is there are so many rules and regulations that it's likely, I kind of compare it to, there's an old saying in, the criminal law context, which is that if a policeman wants to, or a policewoman wants to pull you over on the road while you're driving, they can probably find some little infraction that you committed that gives them a reason to pull you over, because there's so many rules for the road. And the employment law context is the same thing. And it doesn't matter if the employer doesn't know that they were doing something wrong. They'll still be, if they're in violation of the law, they're in violation, and ignorance is no excuse. So, we hear from employers all the time, clients, saying, well, but I didn't know that, or well, I was trying to do the right thing, and that can certainly help. That might be a mitigating circumstance, but generally speaking, it's usually not going to be an excuse. So we recommend assume the employee will always wind up with a more favorable outcome rather than trying to explain away or justify why you might be in the right. So, for example, we've had clients who have a receptionist at the front desk and the receptionist says that she's pregnant, or the receptionist breaks her ankle right after getting hired, and for other legitimate reasons the employer terminates them because they think, well, I have this other legitimate reason, and that may be true, but you're going to wind up in trouble when there's an argument that can be made that the termination was due to the pregnancy or the disability. So you should always look at it from the context of there's some way I might be breaking the law here, and that helps to put employers and businesses in the right mindset when it comes to that being an overly cautious mindset when it comes to making decisions in this context. Along those lines, we hear from clients, not without reason, saying, well, I'm under 25 employees, or I'm under 50 employees, or I'm under 10 employees, so I thought that doesn't apply to me. And while it's true that some rules and regulations, both on the federal and state level, differentiate at certain numbers of employees, more often than not, the more significant rules and penalties are going to apply at any size. So don't lean on small size as a crutch, because it's probably going to end up biting you in the end.
So number 9 on our top 10 list is that improper pay at termination can trigger litigation. And I can't emphasize enough how many cases I've seen where the wrong amount of pay or a delay in pay at the time of termination triggered a bad taste in an employee's mouth, triggered anger at not being paid, and once you start looking for things to find wrong, it's not too hard because most employers aren't keeping perfect records, and everything's not going to be perfect, and it can really open a can of worms. So one way to avoid that is to make sure that proper pay is given to employees at termination. So in California, when an employee is fired, they must be paid at the moment of termination. So you sit down with an employee, you give them the notice that they're being terminated, and we'll talk about some tips for that meeting as well. And before they leave, you hand over their final pay, including any accrued vacation or any other monies that they might be owed if you're holding deposits for uniforms or anything along those lines. So that's immediate at the time of termination. Otherwise, in California, the pay has to either be handed to or mailed to the employee within 72 hours. I know there's someone, or a few people actually from Nevada on the webinar, and the rules in Nevada are you have 3 days. This is a good example of how different the states are and really how employee-friendly California is, because in Nevada, when an employee is terminated, you have 3 days to pay them. Whereas in California, it's immediate. And if the employee quits, you have a week in Nevada, whereas in California, you have 3 days. So some states give you a little bit of a break. Either way, though, it's important to make sure you do this properly because it can trigger other problems down the road.
Number 8, how the employer describes the reason for termination can trigger litigation. So a common reason for litigation is that when an employee is terminated, they say, well, that was a wrongful termination. And what that means is, as you may know, the default employee employee relationship is at will. And that means in practice, you can fire someone for a good reason, you can fire someone for a bad reason, you can fire someone for no reason, but you can't fire them for an illegal reason. An illegal reason would be something like disability, race, gender, that type of thing. So what we often see is employers will describe the reason for termination in a certain way, and that becomes something that can be used against them later on. For example, if the employer says, we had to terminate you because we're downsizing, and then they don't downsize, then the former employee has a good argument that this was a pretext for firing them and it was really because of their gender, disability, etc. So our recommendation is, to keep it simple. You'll certainly want to document things in advance, and we'll talk about that later, but it's usually not of significant benefit for the employer to launch into this detailed explanation because, again, those statements can be used against the employer later on down the line in a lawsuit saying, the reason you said you fired me was something you just made up. You actually fired me for an illegal reason.
I wanted to say, go ahead and do try using the chat box. If you have questions, let us know. We're happy to answer questions, and sometimes it's easier to do that when we're already on a topic. But we should have a little bit of time at the end too. Either way, Patrick and I are good with it. Number 7 on our top 10 list is that the lack of documentation for terminations can increase the exposure of a litigated claim. Just like Patrick was saying before, documentation can be really important. So many times, this is another one of these very common situations. I get a case where the employer is being sued, and the employer says, oh, they were just doing a terrible job, and I decided to let the person go. And the person happens to be a disabled person or someone who could file a discrimination claim, someone in a protected class. And then we go back and we look at the file, and the file looks great. The last review was just 3 months ago, and it was shining, and there were no problems, and there's nothing in the file to suggest that there was any issue with this employee at all. So at the time that you're considering a termination, it's really important to pull out the personnel file and think about what is, number 1, this employee, number 2, this employee's lawyer if they ask for a copy of this file, and number 3, what might a jury think about what's in this file and whether it demonstrates that there was a good reason to terminate the person. You don't always need to have a reason, but I would say in particular where the employee is in a protected class, it's important to document a reason. And like Patrick said, we don't always need to get into a discussion about that at the time of termination, but it is important to get good documentation in the file to justify the termination in case it ever comes up. So if you pull that personnel file and you see that there isn't good information in the file to support the reason that you're terminating the person, then maybe postpone it until there is better documentation. Another example is, say, an employee files a workers' comp claim. And while the comp claim is pending, there's some issues that are discovered with the employee. Now, you might want to think about whether you want to terminate an employee who has a pending workers' comp claim. And if you're going to, you might even want to give the employee the reason why. Say they're discovered stealing or something like that. But it's important to pick your timing as well. I think it's important to use a termination form. I have a lot of cases that we get, and we can't tell from the personnel file when the person was terminated because there was not good documentation kept. I like to say that when you do a termination, it's great to have kind of a script that you prepare in advance where you go over what you're going to say because you've thought about it, and is this one where you need to say something, or is it better to keep it simple, that you're going to hand over the final paycheck if that's what you're doing. that you're going to ask for, keys and any other property the employee might have, because termination can be a really stressful time, and having a script can help. And a form helps also to document when the termination occurred and what was said. Then the script, you initial it, put it in the file, and you've got good documentation of what was discussed during that meeting. And then ultimately get legal advice when it's tricky. If you have a situation with an employee who's filed a comp claim, who's in a protected class, who has made claims in the past about feeling discriminated against based on religion, sexual preference, race, age, all the protected classes, ethnicity, then it might be good to get some legal advice. Call a lawyer. We'd be happy to help you, of course. Go over the personnel file really quickly and make a good decision and have it backed up with some good legal advice.
Hey, Teresa, can I make a point there?
Yeah.
Yeah, I think the form is great because I had a case where what was in the employee's file was not entirely consistent. It was mainly consistent, but not entirely consistent with the reasons for termination discussed at the termination meeting, which wasn't supposed to be a termination meeting, but it ended up getting emotional and heated. And then those topics in the meeting were also a little bit different from the final email the employer sent the employee saying, here are the reasons for your termination. And so again, having legal advice or at least a form or some sort of protocol would help to cut down on the discrepancies between each of these three phases. And unfortunately, the employer did not have that, and as a result, they ended up dealing with a six-figure settlement. And they were trying to do the right thing by documenting things in the file and in the meeting and in the final email, but there was enough wiggle room there that the employee was able to say, I don't think it's credible that that's the reason why you fired me. And they had an argument, and it was not unconvincing. So just kind of a real world example for the fact that emotions, people don't often think about the emotional aspect, but once that gets involved, which is often the case when you're terminating an employee, then it's all the more important to have either legal advice or some sort of protocol or a form to make sure everything's consistent and all the loose ends are tied up. Number 6, correctly classifying exempt and non-exempt employees is critical. This is a common mistake. The background for this point is that the general rule is there are a lot of protections for workers, and those protections are listed on the screen, some of them at least. So those are protections like, if you work over a certain number of hours, you're entitled to overtime, you're entitled to meal breaks, you're entitled to rest breaks, you're entitled to reimbursement for certain expenses, things like that. However, as with many things in the law, there are all kinds of exceptions to that general rule. So if you are entitled to an exception, you're an exempt employee. Exception, exemption, same thing. If you're not, then you're non-exempt. What employers will do, believe it or not, is they'll say, well, I don't know, I don't really want to pay them overtime, so I heard that if they're an exempt employee, meaning they're exempt from overtime laws, then I don't have to, so why can't I just make them an exempt employee? And I'm simplifying it, but more or less it's a process of checking a few boxes and saying, I hereby deem you an exempt employee. The problem is that's not how it ultimately shakes out if it were to go to court. What would happen if it were to go to court is the opposing attorney and the judge would look at all the facts and say, well, based on what this person was actually doing, based on the actual circumstances of their day-to-day job, their responsibilities, the level of control they had, the level of discretion they had in making decisions, they should have been a non-exempt employee. And if that happens, then the employer can be in for a nasty surprise in that they're going to go back through all the time records and say, well, during all these instances, the employee should have been earning overtime, so they weren't. So they'll tack on back pay. They'll tack on pay for meal times, tack on pay for breaks they should have received. They'll tack on penalties. They'll tack on interest. And then with a lot of these wage and hour claims, as Teresa was saying, you owe the other side their attorney's fees. And not to mention the employer has to pay their own attorney's fees. So once you add all that up, it's a huge penalty. So it's worth doing some work up front to make sure that you're actually classifying your employees correctly, even though it may take a little bit of work, and because you'll save yourself so much more in the end. So I think on the next slide we've got an example of some of the exemptions that you can qualify for. Okay, so here are some of the standard exemptions. So for example, like the executive exemption, this is a person that's higher level than your average worker. Similarly, you've got the professional exemption for certain trades. Within the professional exemption, a new one that's been kind of a subset of it that's been getting more attention lately is for computer software employees. A common mistake we see with that is employers will think, well, my employees are dealing with computer software, therefore they qualify for that exemption. But it's not just that simple. For example, this particular exemption has a minimum salary requirement, as do many of them. This slide is just a summary of some of the factors. But again, it's worth, people don't want to do it, but it's worth putting a little legwork up front to make sure people are actually qualifying, and more importantly, reevaluating these things as roles and positions change. Sometimes a small business will have a person quit and they'll say, okay, well, until I can find a replacement, let's have so-and-so take over their responsibilities, or let's split the responsibilities amongst different people. And that can change the nature of someone's exempt, non-exempt status. So I think employers need to be sensitive to that and mindful of the fact that it's, even though it could be onerous, it's worth reevaluating these things, scheduling reminders for yourself to do this every now and then, because in the end you'll save so much money over going to court and losing.
So we got a question backing up a little bit to final pay. The question was, I know employees must be paid immediately. What if payroll was already submitted with the payroll company for direct deposit to be paid 3 days later, and then you terminate the employee? The payroll company won't let you reverse the payroll. So if a check is written at termination, the employee would be double paid. As long as you can prove the payroll was processed, is that okay? And I guess this is where I would say it's important to do some planning in advance of a termination. So I would say that it's a little risky because California is very strict about payment being tendered at the time of the termination, and it's not going to be a good time to ask the employee to waive that, right, because they're being terminated. So my recommendation would be that when you're planning that termination, to give yourself time to let the payroll company know so the check doesn't go through. And I'm a little concerned that the payroll company isn't able to suspend that check. To me, it seems like they should be able to do that. It's not a very good service if they can't help you with terminations. So that would be maybe something to think about in terms of what a company needs with its payroll processor, because most companies, you should be able to pull that check so that the employee doesn't get paid twice. So my recommendation would be not to mess with it. You don't want to pay the person twice. So I suppose what you could do is give them the check, let them know you have the check, show them a copy of the check, let them know direct deposit's already on the way, and ask what they want to do. It's a really bad time to ask an employee for concessions, though. So I would say in this situation, you probably don't want to give the employee that check to take home. But I would make a copy to say, you know, you had it, you told them that direct deposit is coming in 3 days like usual, I would imagine. And then in the future, just plan so that this doesn't happen, because that's a tricky situation to be in. And of course, if you want to avoid these little headaches, planning ahead of time will help. So number 5 in our top 10 list is responses to administrative charges should be treated like litigation. So administrative charges are charges by administrative agencies, kind of like, let's say a person doesn't have liability insurance and they're driving and get in an accident. DMV, the Department of Motor Vehicles, will conduct an administrative hearing to see whether that person should lose their license. And similarly, the government agencies in California, Arizona, and Nevada, and in all 50 states, have the ability to file charges against employers when their employees claim that they didn't get paid properly or that they've been discriminated against. And those charges can be just like a mini lawsuit, and maybe not so many sometimes, depending on what the claims are. So the way you'll hear about them is that the government agency will send a letter saying, we are charging you on behalf of this employee with discrimination, or here's notice that the employee says they weren't paid and we're going to help them collect. And the types of agencies that you can hear from in California are the DFEH, federal, so anybody in any state could hear from the EEOC regarding discriminatory type issues. Disability is a protected class I might not have mentioned earlier. You can hear from, we call it in California EDD, but basically the Unemployment Commission, whatever that's called in your particular state. The Labor Board in Nevada, that's the Commissioner of Labor. In California, it's the Labor Board. And OSHA. And of course, OSHA will get involved when there's some kind of a safety issues. And with all of these agencies, it's really easy for the employee to fill out a form and say, I didn't get paid or I've been discriminated against. They don't have to do anything else but make an allegation. In the case of OSHA, they can say, you know, the workplace isn't safe here because we didn't get training, or, you know, I've been exposed to a chemical. It's really easy. And the allegations can be very costly, and we think it's a good time to get a little bit of legal advice. Treat them like a lawsuit, because if you're not successful at the administrative level, litigation can follow. So all of these agencies exist, at least for the moment, depending on what state you're in, to protect the employee, ostensibly to protect the employee. Now, with our new government administration, that might change a bit, and the focus of some of these agencies might change, and we'll have to see what that's going to be. But for now, they exist to protect the employee, to help the employee get paid, to make sure there's not discrimination, to be sure the workplaces are safe, and they're not your friends. They're not going to help you, so it's important to treat them like an adverse action. Someone's wanting something from you to take your money, basically, when you're a small business, and so you need to defend yourself. It's a good idea to get some advice and treat those like litigation.
Number 4, a professional work environment will discourage many employment-related problems. So that's not a extremely bold statement, but you would be surprised how often adhering to professional standards and reinforcing them on a regular basis would prevent problems with employees. And oftentimes it can be something small that starts to fester, or on a cumulative basis, little things build up. The employee eventually harbors some ill will towards the employer, and then once something is done, like for example, there's a legitimate layoff of the employee, that kind of pushes them over the edge, and all these things come out. They create arguments that, well, what was done was pretext for some sort of illegal act, such as discrimination based on my race, gender, age, disability, those types of things. So, we strongly encourage, you'd be surprised how many employers don't have a section in their employee handbook, for example, that emphasizes this principle. That's not going to win the day one way or another, but it certainly helps to have this type of thing in your employee handbook. And of course, to have it iterated through your other policies, procedures, interactions, etc. So, just to give you an example as to how silly it can really get is, Teresa and I had a case where one of the employees was complaining about the fact that a supervisor had, this was an office environment, and the supervisor brought a bowl of candy and sat it on her desk, and as various employees would walk by, the supervisor would say, "Oh, I brought in some candy, feel free to take some." And when this particular employee walked by, that offer was not made. And this was something that she was bringing up with her attorney as a reason why the supervisor had it out for her due to some sort of discriminatory, illegal intent. And again, it sounds pretty comical, but these types of things build up. Another example is in a different case we had, there was a lunchtime celebration for another employee who, I guess it was their birthday. And I think the employee in question wasn't given an express invite to it, and a couple other employees were. And of course, our clients were saying, "Oh, this is obvious, this is going on. We didn't think we needed to come out and say, hey, you're invited to so-and-so to this cake we're going to share for 10 minutes in the lunchroom." But again, the employee who felt discriminated against thought that was evidence of some sort of ill motive, and that gets the employee thinking about all these other things that were done, and people start to put their own spin on things. So again, trying to keep things professional, consistent, across the board can not only help prevent these feelings, but then also help prevent these arguments once the suit is initiated, because you can show, look, everybody was treated equally, professionally, we're committed to that, and these types of things are being overblown. So keep it professional.
Number 3 on our top 10 list is handling red flags early on can save you lots of money and heartache. I've seen quite often that it's the employees who are given second, third, fourth, fifth chances, who sometimes even the employer's gone out of their way to help them, maybe personally, maybe financially by advancing pay, giving extra leave and things like that. Those seem to, for whatever reason, be the employees who come back and tend to do the most damage. And typically in every termination, there is some looking back, and of course hindsight's 20/20, and realizations that there were red flags that this employee should have been terminated a long time ago. So the red flags are any kind of dishonesty. I think these things go to kind of character, and a person either has it or they don't. And if there is a history of dishonesty, it's usually not going to get any better. Cheating, stealing, any kind of violence. Again, these are kind of character traits. And if you see these things happening with an employee, you don't want to be in a position where 2-3 years down the road, things haven't gotten better. In fact, they get worse, and it gets more tricky and more difficult to deal with. So when you spot these issues, it's a good time to say, this just isn't working out, and to terminate that relationship. If it does happen to be someone who's in a protected class, who filed a comp claim, has a disability, is older, again, it's good to make sure that file is documented, but oftentimes it's better to get the termination over with, because the longer you keep someone around with these issues going on, the more expensive the case will ultimately be, the greater the exposure is. Whereas if there's an earlier termination, it's going to be less of a problem. So these are things to think about when you spot employees involved with dishonesty, cheating, stealing, and any kind of violence.
Number 2, properly classifying independent contractors and employees is essential. This is a huge one, and it's not dissimilar to the exempt versus non-exempt distinction we discussed earlier. The default rule is that all workers are presumed to be an employee, but employees are entitled to a lot of protections that independent contractors are not, and those are things like overtime pay, rest breaks, reimbursement for certain expenses such as mileage. So oftentimes with small businesses, especially ones that are just starting out, is sometimes they'll legitimately need people who should be independent contractors because they're not, I shouldn't even say full-time employees because the full-time distinction isn't determinative, but they may say, hey, I just need you to perform this discrete task for me. And that, I'm simplifying it, but that sounds like, at first blush, an independent contractor relationship. But then once the small business grows, they think, hey, this is great. I'm not doing as much payroll deductions. I don't have to reimburse them for mileage. And they'll say, well, I need someone for only part-time. It's cheaper if I just make them an independent contractor. So essentially, again, I'll just kind of check the boxes to deem them an independent contractor, and then I'm good. But again, it's not that simple. What happens is the facts and circumstances of the actual day-to-day relationship, communications, control is the biggest thing, but all of these things that describe the nature of the relationship between the employer and the worker are what actually determines whether the worker is properly classified as an employee or independent contractor. So even if, and this is even if the worker says, yes, I agree that I'm an independent contractor, that is not sufficient. So that person can turn around after likely talking to a lawyer who says, well, I know you agree to that, but you got a great case that you should have been an employee. They'll file suit, and if they win, they'll be entitled to all the other protections like overtime pay, reimbursement for mileage, all these other things that employees are entitled to. They'll get penalties on top of that. They'll get interest on all of that. They'll likely be able to recover their attorney's fees. Then, of course, the employer is paying their own attorney's fees, and it all adds up very quickly. So, what determines whether or not someone's an independent contractor or an employee? The biggest thing is control. It's actually a pretty complex determination. That's why people like Uber and Lyft are paying tens of millions of dollars to settle these claims, because it's not clear how it would shake out in court. Because it's a complicated test. I think the IRS has 20 different factors to consider for whether someone's an independent contractor or employee for their purposes. I think California's got like an 11 or 12 factor test. And again, these are factors. These are not bright line rules most of the time. So you could have a situation where, okay, 5 of these factors seem to weigh in favor of employee, 6 seem to weigh in favor of independent contractor, and it can be tough to make that call. But what's important is that the employer is not just making a blanket determination that, well, I'm going to make everyone an independent contractor, that'll save me a lot of money, and not actually considering these factors, and on top of that, not documenting the fact that they're considering these factors. So this one, again, it can be, it's not fun to do the legwork up front on this, but in the end, it just can end up saving so much money because there's so much exposure for employers that don't correctly classify their workers.
I have a good example of this. It's really important to look at what is the person doing and what is the business of each entity of the employee and the potential employer. So, for example, in a case we are involved with that involved a class action lawsuit, a company who hires tutors to go out into the community and tutor children hired the tutors as independent contractors. And that just didn't pass even really first muster, because if the business is hiring tutors, then the people that you hire to do that work are not going to be independent contractors. If they're performing the essential functions of your business, then most likely they are your employees. If they're doing something different, so if, for example, they're coming in and setting up your computer network, or doing electrical work, or interior design, something that's completely different for the tutoring company, then yeah, those are independent contractors. But when the employee is doing the work of the company, that's a big red flag that that's probably going to be an employee and not an independent contractor. Okay, so we're on number 1 now. So be thinking about any questions you have, because we're going to have a few minutes to answer questions. Number 1 is know what's trending for small businesses. We're talking about California. I have a link down there to what the Department of Fair Employment and Housing, which is the California agency that handles discrimination claims, it's their report about what they're going to focus on. And every agency does this. So whether you're in California, Arizona, or Nevada, whatever the relevant agency is that deals with the type of claims that you might be concerned with, you can look and see what are they saying in their annual report that they're going to focus on this year. And of course, we know there might be changes in the focus of various agencies with our new national administration, and that can have an impact on states. So check that out. In California, the focus is retaliation claims. Retaliation claims are claims that an employee complained about something and then was retaliated against, and those can be some of the largest verdicts that we see. And it's because initially, dealing with a discrimination claim and what you do is one thing, but then retaliating against the employee is seen as far worse. So those claims can create larger verdicts than really any of the others. So when someone's made a complaint, be thinking about how you're dealing with that. And that's a good time to get some advice too. If you're thinking about what we call an adverse employment action involving an employee who made a complaint of some kind, that's a situation involving some planning and thinking about to make sure that you don't increase your exposure. In California, the DFEH is going to be focusing on disability rights. And I would say this is probably true for most states across the board. The population is getting older. Baby boomers are getting into the ages where they're experiencing disability, and it's a large group that's going to have a lot of issues, and they're an outspoken group of people too. So we can see that baby boomers are going to be pursuing their rights as disabled people, and those claims are likely going to climb. Gender discrimination, as always, is something to be on the lookout for. I think we might be seeing more race discrimination cases, whether there's actually something that's happening that's new or different, or just because people are more sensitive to the issues in the current climate. That will remain to be seen, but I expect to see more of those. And age discrimination, again, with the large population of baby boomers getting older, the DFEH is focusing on those claims and making them a priority, but we're also going to see more just because a large group of the population is getting older. So that's what we expect to be trending, and that means that when you have an employee who falls into any of these categories, made a claim, could think they're being retaliated against, is disabled, a female, is non-white, older person, we say over 35, could be someone who could pursue an age discrimination case, which to older people sounds a little ridiculous, but it's over 35. If an employee is in any of those categories, then you want to be extra cautious with what you're doing with respect to their employment so that you don't increase exposure and trigger litigation. I'm going to check and see if we have any questions. I'm not seeing any. If you have any, this is a good time to ask. Patrick, did you have anything else that you wanted to elaborate on?
I don't think so.
Let's see what our next slide is. So if you have questions, this is how you can reach us. Our email is there, Patrick's and mine. We both handle employment matters routinely, both large and small, for all kinds of businesses. And sometimes we also get involved on the other side, particularly for high-paying executives who are experiencing issues in the workplace, including severance agreements and disability claims, but kind of the bigger ones for higher paid executives. If you have those issues, we're always here and happy to help. I'm spotting some typos on this slide, so I want to change it really quick. Maybe you won't see them. So we want to thank you for participating today. If you have ideas about other webinars we can do that would be helpful to your businesses, we're happy to tailor webinar presentations. These are so easy because you can have lunch at your desk while you participate and learn a little bit at the same time, and you don't have to leave your office. Super convenient, and we're happy to do them for our clients and our potential future clients. So let us know what you thought about today's presentation, and let us know if there's any other topics that you'd like to hear about. And seeing no questions, we're going to go ahead and sign off. Thank you all for participating today.
Thank you very much.